Assalamualaikum warahmatullahi wabarakatuh to Madam Malaini. Today our group will be presenting about partnership and company law, question number 4. So before we get into deeper, let's get to meet our team first. So here's our 4 team members. At the top left we have Nur Adlina. At the bottom left we have Muhammad Muizzuddin. At the top right we have Wan Yusof Adani. And last but not least, me, Nazim Nahazian. Question 4A. So, A, B and C are partners in a law firm. Over time, serious disagreement arise between A and B regarding the management of clients and allocation of work. The disagreement so severe that the cooperation between the partners becomes impossible and the firm starts to suffer. C, though natural, it finds difficult to continue the partnership under these circumstances. So, the main question is, can the partnership be dissolved on the ground just and equitable circumstances? And who can apply to the court for dissolution of this firm in this case? So, let's discuss go to the introduction first. So, let's get to the main point. Can the partnership between A, B and C be dissolved due to irreconcilable disagreement? And who is entitled to apply for dissolution under the just and equitable ground? So, I'll pass to Wan Yusof Adani to explain you the relevant law so that we will know can the partnership be dissolved and who is entitled for this case.
So let's move on for our relevant law. There are several ways to dissolve a partnership, and one of it is Section 37, Clause F, just and equitable by dissolution by the order of the court. So Section 37, Clause F, on application by a partner, the court may decree a dissolution of the partnership whenever in any case circumstances have arisen which, in the opinion of the court, render it just and equitable that the partnership be dissolved. Therefore, if anything happen in a firm and fall under just and equitable, the court may grant an order of dissolution upon an application made by any partner. In Rayenich case, the company was dissolved even though they were making profits. This was because the two persons in the firm who were the only directors and the only shareholders had reached a deadlock and only communicated through their secretaries.
So, for application, in this scenario, the partnership consists of 3 partners, A, B and C. However, serious and ongoing disagreements between A and B have made cooperation impossible. As a result, the mutual result and confidence required in a partnership relationship is no longer exists. Because a partnership is based on mutual confidence and cooperation, the constant conflict between A and B has paralyzed decision making, because decision making is one of the most important thing in partnership. So this has directly affected business, causing it to suffer financially and operationally. Therefore, the partnership cannot be carried on to the advantage of all partners, which is a key consideration under the law. Although C remains natural and is not directly involved in dispute, nature alone is not sufficient to save the partnership. The breaking down between A and B has created a situation where the businesses cannot function effectively as a whole. This shows that the partnership is effectively broken down, even if not all partners are in conflict. So according to Section 37 Clause F of the Partnership Act, the court may order a dissolution where circumstances have arisen that make it just equitable to do so. So in this case, there is a complete loss of a mutual trust between key partners, which is A and B. So the business is no longer profitable or functional, and the partnership relationship has become unworkable. These factors clearly satisfy the just and equitable ground for resolution under Section 37 Clause F. Importantly, the law allows any partner, whether directly involved in the dispute or not, to apply for resolution. This means A and B or even C may apply to the court under Section 37 Cross F. The right is not limited to the aggrieved or disputing partners but extends to any partner who can show that the partnership can no longer continue fairly. So, with all the relevant law and application, I will pass to Yusuf to make the conclusion so we may know whether the partnership can be dissolved and who is entitled to apply for dissolution. Thank you.
So the last part for this question 4A, the conclusion. Yes, the partnership can be dissolved under Section 37 Clause F of the Partnership Act 1961 because of the just and equitable situation. C may apply to the court for dissolution of the company.
Now, I will present question 4B, which deals with the liability of partner under partnership law. The question is, A, B, and C are partners in a construction firm. While negotiating a deal for the firm, A learns of an opportunity to buy construction material at a heavily discounted rate. Instead of purchasing them for the partnership, A buy the materials personally and later sell them at a profit. Has a Veloci any duty as a partner? What is A required to do under partnership law regarding the profit earned from this transaction? So, this is introduction from this question. The issue is whether A has violated his duty as a partner by purchasing construction material personally for profit, and what must A do with the profit earned under partnership law. Okay, for this part, I will explain the law relating to partnership issue. Under Section 31 of the Partnership Act, each partner has a fiduciary duty to the firm and to the other partners. This means that a partner must act honestly in good faith and not take advantage of the partnership businesses. This section clearly states that if a partner, without the consent of the other partners, derive any profit from a transaction in connection with the partnership or the use of the property name or business relation of the partnership, then such profit must be written and accounted for to the firm. In other words, partners are not allowed to secretly profit from the partnership business. This principle asserts that the relationship between partners is based on trust and honesty. This principle is supported by Bentley versus Craven. In this case, the court held that partner cannot make secret profit from the partnership business. Any profit obtained honestly must be returned to the firm, even if the business is still profitable. Therefore, based on Section 31 and the case of Bentley versus Craven, it is clear that the law protects the interests of the firm and other partners by ensuring that each partner acts fairly and ethically. So, let's move to Adelina for present other parts. Okay.
So next, I will explain the application of the law to this case. So in this case, A learned of an opportunity to purchase building materials at a discounted price while he was carrying on a partnership business with B. However, instead of using this opportunity for the benefit of the partnership, A purchased the materials in his personal capacity and later resold them for his own profit. So this opportunity should have belonged to the partnership because it arose during the course of the partnership business. So by using the opportunity for his personal gain without the consent of B, A has breached his fiduciary duty and duty of good faith as a partner. Therefore, A's actions are considered a misuse of partnership opportunity. Next, in conclusion, yes, A has breached his duty as a partner. Under Section 31, A is required to account for and remit all the profits he earned to the partnership. This is because the profits obtained from the opportunity belong to the partnership and not to A's personal property. Hence, A must return all the profits to the partnership as his actions were against the principles of good faith and fiduciary duty in a partnership. Okay, I guess that's all for our presentation. We hope this explanation has helped you to understand the situation and the cases given. So thank you for your time and attention.